This is your healthcare agent. You trust them. You absolutely trust them to make healthcare decisions for you, but they can't do this. They can't do this. They must do this. They shouldn't do this. They should never do this. Hi, this is Jeff Mersace, the Plain English Attorney, and today I'm going to answer a burning question that seems to keep coming up these days in meeting with my own estate planning clients. It's what's the difference between a healthcare power of attorney, a living will, and a DNR? And, well, sometimes the question is simply, what's the difference between a living will and a DNR? And often my clients want all three. And I'm going to tell you why that's probably not a good idea. All right, so let's start out with the basic one, the healthcare power of attorney. What exactly does this do? Well, a healthcare power of attorney lays out, here are people who can make healthcare decisions for me if I'm not able to. So it lists the different powers, what they're allowed to do or not do. Now, I tend to keep it very broad with my clients. What we don't want is to have, this is your healthcare agent. You trust them. You absolutely trust them to make healthcare decisions for you, but they can't do this. They can't do this. They must do this. They shouldn't do this. They should never do this. This may involve wanting to have a discussion with your healthcare power of attorney agent to make sure you're on the same page. But the more you do, you shall do this, you can't do this, you must do this, you're kind of taking away their discretion to make decisions under fire. Now, one thing that I've seen, I had somebody that it was one of these fill-in forms that they received from one of their doctors, and they filled it out and they put no amputation. Okay, so I saw that and I said, wait a minute. No amputation. Why do you want that? Well, I'm a type 1 diabetic, and if they were ever going to cut an arm or a leg off, I would just rather they let me go. All right, but no amputation also means if you get an infection in the little part of your pinky and they could amputate just that down to that first little knuckle, and then suddenly you can live for another 30 years. Nope, no amputation. Well, look, if you instead gave all the authority to your healthcare agent to make that decision for you and you explained to them if they're going to take an arm or a leg, then I would rather you let me go. Well, okay. So then the doctor turns and said, hey, we've got this infection in the pinky. It could spread. It could become sepsis. If we don't amputate, we're just going to amputate right down to that first digit. Okay, I know that's not what he meant when he was really thinking about not amputating. He was talking about like a whole arm or a whole leg. So, all right, yes, go ahead and do it. You've got to be able to give them that discretion. But it's that broad range of everything leading up to, in North Carolina, the definition is you're terminal and incurable, or you're in a persistent vegetative state. Right, when you reach that point, that's when something like a living will can kick in, and now suddenly that final decision about withdrawing life support, withdrawing artificial nutrition and hydration, you're making that one final decision in a living will, and that's it. Now, the living will is not the same in every state. They may have different criteria. And I don't know if it's the same way in New York anymore, but when I was in law school in New York, your living will didn't make the decision. It specifically empowered someone to make the decision. So it could be someone separate from the person who was your healthcare power of attorney agent. So that's how the living will worked in New York. But in North Carolina, we call it, well, my clients call it, it's the, quote, pull the plug document. So it's your wishes and your order to a doctor. So often that living will and that healthcare power of attorney are part of the standard packages that we put together when we do estate planning. They work in conjunction. Well, what if you don't have a living will? Well, then the way we draft the healthcare power of attorney, that decision defaults to your healthcare power of attorney agent. They now have to make that decision for you. All right, so then what's the difference between a living will and a DNR, a Do Not Resuscitate order? We can't do a legal document that's a Do Not Resuscitate order. A living will is your order to physicians. Here's what I want you to do. A DNR is an order from physicians to other medical personnel. So let me give you the scenario that I typically give to my clients when I'm telling them the difference between a living will and a DNR. If you do your estate planning, we have a living will, it's put in place, and you make copies of it and you put it up on the, on the refrigerator, above the bed, everywhere, and you have a heart attack and the EMTs rush in and someone says, they have a living will, they have a living will. They're just going to push them aside and they're going to revive you and they're going to take you to the hospital. But my living will says to let me go. No, your living will is an order to a doctor. EMTs are not doctors, and it's not determined that you're terminal and incurable or you're in a persistent vegetative state. They're going to revive you and they're going to take you to the hospital. All right, well then what's the DNR? The DNR is an order from a physician. The paperwork is all done by the physician, and it's their order to medical personnel saying, do not revive this person. Let them go naturally if resuscitation is an order. So you take that, you put it in the refrigerator, post it above the bed. EMTs rush in. They have a DNR. Okay, it looks like it's an order. We're just going to let them go. Well, why would we do that? The more extreme example is really the one that explains it the best, so I'll give that one. There's a senior in their mid-80s. They've already had a few heart attacks. They've got brittle bones. And if they have another heart attack and they're using the paddles or they're doing compression, it's very likely that those ribs are going to crack. And even if they bring them back, it would probably only be for a few weeks and they'd be in agony the whole time. So that's when the decision made by the person and their doctor, yes, we want a DNR in place. So when my clients want to know about a DNR, no, that's a discussion to have with your physician about the DNR. Legal documents, we can do the healthcare power of attorney and the living will. So that's the difference among those three documents. So I hope you found that information useful. As always, please subscribe to the channel, click like, share the video if you think it's important. It really does help out the channel. If this is information that you think other people should have, then helping out the channel with those likes and shares really, really does get the word out. So as I always tell my clients, please stay safe, plan ahead, and enjoy life. And whatever you do, make it a great day.